All right, hey everyone, Jeff here at StopThePirates.blogspot.com. Falling behind on your mortgage payments? You need to dispute the debt as soon as possible before it gets too far along in the foreclosure process. Do not just dismiss these notices and things that you get in the mail. So this letter we've put together here, this dispute the debt letter, goes something like this. You put the name and account number at the top left. And the first paragraph here, this constitutes an official notice in accordance with the Fair Debt Collection Practices Act and the Truth in Lending Act, that I hereby dispute the debt in the above referenced account. It has come to my attention that there have been some accounting irregularities in this account which have adversely affected me. In reviewing this account, it has come to my attention that fraud and/or other violations of public policy may have occurred in the operation of this account. Therefore, I will be conducting discovery to determine the true facts in this matter. This constitutes the exhaustion of my administrative remedy in accordance with the Administrative Procedures Act as concerns the above referenced matter. This discovery process has been presented under notarial seal for the purpose of certifying the admissions, confessions, and stipulations of the parties, to create a public record thereof via the issue and filing of an administrative declaratory judgment by notarial protest. Said administrative declaratory judgment is issued under statutory authority and under the authority of the Secretary of State, acting as agent of the Department of State, and carries the power and authority as if issued by the highest court in the land. Said judgment constitutes res judica, stare decisis, collateral estoppel, and judgment by estoppel. Please take note that this discovery process has been served under notarial seal and valid subpoena, establishing your mandatory obligation to timely respond and/or rebut the following point by point and line by line, verified, true, correct, and complete, signed, sworn, and notarized in affidavit form, and to provide certified copies of the requested documentation. Thank you. You don't get any more solid than that. Follow it up with your notarial seal and your certified affidavit of truth. Please respond to and/or rebut the following point by point, line by line, in affidavit form, and provide documentary evidence to support your claim. Now, who at any loan servicing company or mortgage broker or company that's coming after you, attorney, is going to take the time to do that? None of them. They'll just put you in this pile over here with people we don't want to deal with, and that in by itself is going to let you win the situation. Is there a lack of response? Because legally they have to respond to this type of letter, just like you would to the IRS. Anyway, first point, and this is kind of obligatory, but it puts them in the right mindset nonetheless. It has come to my attention since 1933, when Franklin D. Roosevelt took all of the gold and silver out of circulation, that we have no currency of value or substance with which to pay a debt. Our economic system operates on credit and debt. If we have no currency of value or substance in circulation today, then one must wonder, what did the bank loan me? It is unlawful for a bank to loan me their credit. It's true. They can't loan you money, or what we think is money. So what did the bank loan me? Question mark. What value, substance did the bank loan me? There has to be equal consideration on both sides of the table. And there isn't. If you fill out a 1003 loan application, it's a one-sided contract. It's you're just taking out your credit. Please provide the evidence that the bank loaned me anything of value. Point two, at the closing, I placed my signature on a promissory note which gave the bank in the exchange. Said promissory note had no value prior to my placing my signature on it. Did it not? There are no other signatures on said promissory note. Therefore, it was my signature that gave the value to the promissory note, which I gave to the bank in the exchange, was it not? Since 1933, the United States has operated upon the good faith and credit of the American people, not the good faith and credit of the banking industry, has it not? The government, including the government-sanctioned corporation, institutions, and banks, have no authority to create money. Only we, the American people, can create money. We, the American people, are the originators of the money and are therefore the creditors, are we not? When I placed my signature on the promissory note, giving value to the note, I was the originator of the funds and therefore the creditor of the transaction, am I not? Ohio Code Section 1707.01B and other similar state codes define a promissory note as a security. Title 12, Section 1813L1 states that when one deposits a promissory note, it becomes a cash item. Ohio Code at Section 1707.261 states that I have a right to restitution and rescission if the bank sells an unregistered security. It's come to my attention that the promissory note, which I executed in an unregistered security, and then it may have been sold, traded, or assigned in valuation of state statutes. Please provide me with a certified copy, front and back, of the original promissory note, which I signed and presented to the bank in this transaction, and the lawful authority which authorizes the bank to engage in the sale of an unregistered security. In this transaction, your failure to provide me with documentary evidence of the lawful authority shall constitute your stipulation that no lawful authority exists, and your tacit confession to this unlawful sale of an unregistered security in violation of state statute. It has also come to my attention that shortly after the closing that the bank deposited the promissory note as a cash item and the ledger and said note as a liability in the bank's payables account and identified me as the creditor in the account. Did they not? Question mark. It is also my understanding that the bank, in accordance with general accepted accounting practices, ledgered the mortgage as an asset in the bank's receivable account and identified me as the debtor in the account. Did they not? It is further my understanding that because I failed to see through the bank's carefully designed illusion and instruct the bank to make the financial adjustments to zero, the account in the set-off, the bank posted their liability, my asset, in their payable accounts as an off-balance sheet entry, and after a period of time, the funds were claimed as abandoned funds, were they not? Yeah, that's how they do it. They put all your payments that you make on your house into an escrow account, and once you refinance or sell the house, they go to the IRS and said, someone abandoned these funds in this account, do you mind if we keep it? And they said, no, go ahead and keep it. Because you paid for the house with the note which you signed. The trickery there is they get you to sign a deed of trust also, and then they take the first payment out of the when the loan funds. So if you never made one payment, you could just walk away and say the house is mine, but they automatically take the first payment out, which in their funny guerrilla law math it shows that you agree to the terms and conditions of the so-called loan. It's also my understanding that the international accounting system called Basel II and or Basel III have been fully implemented, that off-balance sheet accounting is unlawful, and that all banks and lending institutions must be in compliance therewith. Are they not? Please provide documentary evidence that you are Basel II or Basel III compliant. Uniform Commercial Code 3-104A and C and UCC 105 A and C makes it clear that I was the issuer, drawer, maker of the note, and that I executed giving it value at the closing, while UCC 8, 102, 1215, 9, UCC 8-105 leaves no doubt that I am the holder of the entitlement right up to the funds. I am the creditor and the entitlement holder with the authority to issue entitlement orders as concerns this transaction and or the account, am I not? And I'll leave it there. This is a 3-page letter. And if you'd like a copy of it, and it works, and we've had really good success with it, go to stopthepirates.blogspot.com. Thanks.